Hello, everyone, and welcome back to Immigration and Jobs Talk Show. And this is where we discuss the latest trends and insights shaping the immigration landscape. And I am Nipasa Pradhan, friends. I'm going to be your host for the next hour, and we're going to have a very special guest to discuss about a very essential and important topic that is very fascinating as well at the same time. So I think we will have a good time today, and we're going to be joined once again by none other than immigration attorney expert. Prashanthi Reddy. Thank you so much for joining us once again on Immigration and Jobs Talk Show. Welcome back. How are you doing today?
I'm good, Nipasa. How are you?
I'm also doing good. So good to see you once again. And yes, Prashanthi, today as well. I'm very excited because I mean it's become a regular thing, and it's always good to see you. In fact, I look forward for Wednesdays, so that I get to catch up on all these important topics. So yes, the very important message also before we start off with our topic today is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. And, friends, today our topic of discussion is going to be, about if your H-1B is denied. I mean, what are your other options? So, we are going to discover other alternatives together, the different visa options that you have, and once again, I'm very excited to have none other than Attorney Prashanthi Reddy. She has been an immigration attorney for over 25 years. So, Prashanthi, would you like to tell us about yourself and even your law office before we start off today?
Sure. I am located in Midtown Manhattan, and I have, as Nipasa said, over 25 years of experience in immigration law. In fact, since 1997, I have been practicing immigration law. And we do a lot of business and some family, but predominantly business immigration. H1s, TNs, green card cases, EB2, EB3, EB1. And we also do family based cases, I-130s, 485s, etc. So we'll be happy to, uh, you know, if anyone has any questions, they can email me later. My email address is displaying on the screen. Yeah, so let's start, Nipasa.
Absolutely. So today, friends, I hope you are very excited as well. We'll be looking into different alternatives you have in case your H-1B is denied, or anyone maybe your friends are going through such a situation. Maybe you could share this link with them and ask them to join in. And wherever you're joining us from, right now we are streaming live on YouTube, LinkedIn, Facebook, and Twitter. Thank you so much, all you folks, wherever you've joined in. And if you have questions, put them in the comments below. We'll be very happy to take them up, and Prashanthi as well is going to be very excited to answer those questions for you. All right, so let's dive right in. And I got my first question for you displaying on the screen, and that is, what options do folks have if their H-1B visa gets denied or isn't picked in the lottery?
So, yeah, this I guess session is important because not only for people, even if you haven't had a H-1B denied, it's useful to have this information and keep it for you keep it and save it in your memory so that if you ever encounter such a situation, and it's not uncommon, you shouldn't panic because knowledge is, power. So you will have the knowledge to be able to then proceed forward even if you have a H-1B denial, and you won't panic, and you'll know exactly what to do. So it's important to, even if you're not currently in that situation, to have information of on what to do if a H1 does get denied. What alternatives there are, what can be done, can an appeal be filed, can you refile the H1, especially if it's a cap case, are there alternative visas then you can file for. So these are some of the things that we're going to talk about today. The first question that Nipasa asked is, what options do folks have if their H-1B visa gets denied or isn't picked in the lottery? So it's actually a two-part question. One is, if it gets denied, it depends on what your status is presently. So if your H-1B gets denied, and if it's a cap case, then you'll have to look for alternatives um, for the H1. So you have to look at the other work visas. Also, this applies if you're not picked in the lottery as well. You could, of course, apply for the next lottery in both cases, whether denied or not picked, or you have to look for alternative, um, alternative work visas. You could also apply for an appeal. You could file an appeal. If it's denied, it may mean that the USCIS has denied it erroneously. So you could fight your denial by filing an appeal, and it could be that last time you were not able to provide some information, and that information or documentation has now become available to you, and you can provide that documentation on an appeal and easily get it approved. So it's not the end if you get a denial. There is such a thing as an appeal, which you have to file within 30 days of receiving the denial notice. And usually takes about 6 months, 4 to 6 months for them to respond to the denial. So you have to make sure, well, while your appeal is in progress, you are in status in the sense that you can remain in the country, but you cannot work unless you already have a status which allows you to work. So, in addition to appealing the case, say you appeal it and it's still, it gets denied on appeal, you can then look at alternative H-1B routes, alternatives to H-1B. So the first would be seeing if you can find a job with an employer who's CAP exempt. So a CAP exempt organization is an organization that is an institution of higher education, or it could be a non-profit company related to an institution of higher um, education, or it could be a non-profit research organization or a government research organization. So all these are CAP exempt employers. So you could be working for them directly, or you could be working for them through a consulting company. And these organizations, one of these organizations could be your end client. So either way, you are CAP exempt. The other interesting note that I have for you is once you file a CAP exempt petition, then you could file a concurrent CAP subject petition, meaning you could now work for your original employer who you wanted to work for by first working for this CAP exempt organization, maybe part time. Maybe you will work on weekends for the CAP exempt organization doing some research, etc. And the rest of the time you will work for the CAP subject organization. So that's possible. You can concurrently file a CAP subject petition if you have a CAP exempt petition. Not many people know this. So it's very, very, very important to know that this is possible. In addition to this, there's some other um, work visas such as O1. O1 is generally reserved for individuals who have extraordinary ability. It could be in the sciences, in the arts, in education, business, sports, television, motion pictures, etc. So whatever applies to you. You could also be apply for a P1, but a P1 is more a performance visa. So a person who qualifies for a H1 may not necessarily be in the performance category. So an O1 would make more sense in your situation. In addition to that, there is also the L1, the intra-company transferee. You can have your company if you're working, if you qualify, that is, if you worked in the foreign company or the parent company for a period of 1 year in a managerial position or an executive position, and then you moved here to the US entity, then you may be eligible for an L1A. If you have specialized knowledge, if you have specialized knowledge of the company's product, and again, you worked in the parent company for a year, and you're moving now, or you've already moved to the U.S. company, you could also qualify for an L1B. Both the L1A and L1B allow you to work in the U.S. For that employer. The L1A is great because it's leads itself to an EB1 green card, and we all know with the Indian nationals, the green cards are so backlogged that EB1 is very valuable because it's the least backlogged of all the categories of all the EB1, EB2, and EB3 employment-based categories. So the L1A is very interesting and useful status to be in. And we can discuss the entire session because L1 can be a session by itself, but we can, answer further questions if anyone has on the L1. But let's move on to the next type of visa. That's the TN. The
Sure.
TN is available for Canada,
Canada.
nationals of Canada and Mexico. So if you were born in Canada or Mexico, you can be on a TN visa.
Hmm.
And this is very similar to H1 visa. There are certain designated occupations, and those designated occupations you can find in the NAFTA guidelines. If you
Hmm.
type in TN designated occupations, it should come up on Google. And those occupations, the list will have the occupation as well as the education required or the work experience required to qualify. So as long as you qualify under those guidelines, you can apply for a TN. The good thing about the TN in Canada is you don't have to apply at the consulate. You don't have to apply at the US. First, for
Okay.
a I-797 approval, you can just go to the port of entry and apply at the border for a TN
Okay.
Canada. So that's an interesting thing about the TN Canada. For TN Mexico, you'd have to apply at the consulate, but again, you don't have to apply with USCIS. So that's
Hmm.
still much better than the other work visas where you have to first get an approval with USCIS, then go to for a visa. So it avoids
Hmm.
that step of having to face scrutiny at the USCIS level. The
Right.
other country-related work visa is H-1B1 for Singapore and Chile. It's the same
Hmm.
as the H-1B, but it's designated for Singapore and Chile. The
Hmm.
other one is Australia. If you're an Australian national, you could always file for an E3, which is again very similar uh, to a H1. They require that the position be in a specialty occupation requiring a bachelor's degree in a specific field. And for the Australian visa, also you can apply at the consulate directly. You don't have to apply with USCIS. Um, you also have the E1 and E2 treaty trader, treaty investor visas. This is
Hmm.
not for Indian nationals, but this is if for certain designated countries. And again, you can find the list on Google. If you
Okay.
type in E1, E2, treaty trader, treaty investor countries. So if you belong to one of those countries, you can apply,
Hmm.
you can invest in the US and apply for an E1 or an E2 visa. It's a non-immigrant visa, and you're allowed to apply for a green card as well. And of course, you can always go back to an F1. You can be on an F1 status and get OPT after you've completed your F1, or you can be on CPT, while you're studying, and that is one way of working as well. And last but not the least, you could file directly for a green card. Especially if you were born in some other country, you could file directly for EB1, EB2, or EB3 green card and come that way. Or if you're present in the country, you can file, and once you file the 485, you can file for EAD and start working that way. For Indian nationals, this becomes a problem because green card, in order to file for a 485 and get that work permit, you have to wait for a priority date to become current, and the priority dates for Indian nationals are retrogressed in most categories. EB1 also, but not as bad as EB2 and EB3. And then, of course, you can wait until the next year, April 2025, and then file for the cap in March rather, and file again, try your luck with the cap again next year. So these are a few of the available options that we have in case your H-1B gets denied and you are cap subject.
Absolutely. Thank you so much for that. I mean, so see, there are so many options out there for you folks, and you just have to look out and maybe consult an expert. So, do you need an attorney? Maybe yes, you do. Consult them and check out the best option for you. They will be able to guide you and direct you. So, Prashanti, we already have so many people asking questions, and I think we should take up some of them. And I'll just say hi to Neha, Nids, and Sunil Malhotra. Zaki, Shivangini, Samiksha, thank you so much for joining us and your questions. Stay with us. We will be taking them up. So let's go with Nids. He has actually a series of questions. So I don't know if we should take them one by one. Let me just start with the first one. So this one is by Nids on YouTube asking, my employer does not want gap in my work between the transition to day one CPT for their administrative purposes. They prefer that I take paid time off. My chosen university does not have a term that coincides with the transition. There is a 10 days gap. Is taking paid time off for a 6 days during transitioning between day one CPT and STEM OPT illegal? Let's answer this.
Uh, yeah, I think rather than taking paid time off, that is not meeting the requirements. If you don't have work authorization, then you're not allowed to get paid.
Right.
So there
So,
is no question of
let-
paid time off.
so
It's not about working, it's also about getting paid.
right,
So
right.
you cannot get paid for those 10 days. You have to leave the company and, in fact, rejoin because now you'll be rejoining on a different STEM OPT status. So you'd have to do the I-9 and go through the I-9 verification, etc.
Right. So, he still continues saying that it's a bit of a tricky situation. My employer had layoffs recently and can't start my perm process for another few months. My H-1B expires in 2 years. What could I do? And his next thing that he's saying is he's already looking for new jobs, but the market is pretty bad, it seems. But plus, most employers won't wait for 1 year before start won't wait I guess won't wait for 1 year before starting the perm process. Not really sure what are my options at this point.
So I guess in his second question, can you go back to the earlier one, right?
Sure.
I guess in the second question, he's basically told us what his status is. He hasn't previously. He was asking about STEM OPT and OPT and this and that. But looks like um, he's on a H1 and it expires in 2 years. So you do have
Hmm.
time to, I'm presuming his 6 years expire in the next 2 years. He's on his second leg of his H1. That's why he's worried about the green card processing.
Right.
Um, so I don't see the problem. You still have time. You have 2 years left, and that is sufficient time to file your green card, even if it is, and get the I-140 so that you can get further extensions on your H1. Even if
Hmm.
the process starts a few months later, that should be fine. Just start your process as soon as your employer is ready to start it in the next few months.
All right. All right, so all the best, Nids. I mean, you still have time, you're lucky there. So let's see if you have more questions. We're still here. You can keep posting your questions in the comments. We'll take them up. All right. Should we take another one, Prashanthi? This one is
Yeah.
from Sunil asking, how do visa denials impact an individual's future immigration prospects, such as applying for permanent residency or citizenship?
It doesn't really, unless it's been denied for fraud. A simple visa
Mhm.
denial could be for many reasons. Could be that you don't have the right documents, the employer doesn't have the
Mhm.
right documents, they're not satisfied with what you've submitted, you don't qualify for what you say you qualify, but that's not necessarily fraud. If there is some misrepresentation of the
Mhm.
material facts, if you have submitted a document which is submitted a document which is incorrect or fraudulent or then it's a problem, but otherwise a visa denial doesn't impact your green card or your citizenship application.
Okay. Thank you so much for taking that up. And Sunil, I hope that answers your question. If you have anything else, we are here. All right, so there's somebody greeting us and excited to explore diverse visa pathways beyond the H-1B. Can't wait to gain insights from Prashanthi Reddy, ESQ, and Nipasa Pradhan. Well, thank you so much. And may I know who's that? Oh, Dilwar Hussain. Okay, thank you so much. This is really very exciting. Thank you, and hi to you. Thank you so much for joining. If you have any questions, please drop them in the comments below. All right. And next up, let's take up this question from Zaki on YouTube again, asking, are there any specific industries or professions that are more suitable for certain alternative visa options?
It's not about, for example, if we take up the L1, it's not about the industry. It's more about what your role is in the company. So you have to be, especially for the L1A, you have to be in an executive, um, executive or managerial role. Of
Mhm,
course, we could say that if it's a smaller company, it's more difficult to show the entire org structure and to show that, several people are reporting to you. For the L1 manager, two levels of people have to report to you. So, for example, if you were to work in a business that requires them to hire no employees or less employees, then it may not suit, may not be
mhm,
the best kind of business to file an L1A. So, for
mhm,
example, a jewelry store where they, because of the inventory, the type of inventory, and security concerns, they may not hire too many people, and they may not need to as well.
mhm,
So it might be more difficult to get an L1A in that situation, though I have done it. It's possible, but it might be more difficult. On the other hand, if it's a big multinational organization like your Tatas or Tisco, Wipro, or one of those
mhm,
companies, Google, it's much easier to do an L1A because they already have that structure in place. They're huge. It's easy to show that they require more than one manager, many managers,
mhm,
in their organization. If it's a smaller company, it's difficult to show that they require, if they already have a manager, that they require another manager, or they require, if they don't have various departments, it might be difficult to show, that there's a manager in each department because you have to have a department to have a manager. And so a small company may not be organized into different departments. So it's more about, I think, the type of the number of employees, the size of the company, more so than any specific industry type.
mhm. Okay.
For the other,
Thank
for
you.
the
Thank you.
other visas, for the other
Yes.
visas, the TNs, the E's, it's about your job, and it really, the type of company doesn't matter at all. For the O, it's
Okay.
about you, so it doesn't matter what the type of company is, as long as they can show that they need you.
Extraordinary person, right? I mean,
Correct. Yeah.
right. All right. So thank you for taking that up for Zaki. Well, we will take more questions from the audience very soon. But before that, I wanted to ask you, Prashanthi, if you could explain the process of applying to H-1B cap exempt roles in healthcare and higher education.
Right. So that was one of the cap exempt. One of the ways that you can file a H1, even if your H1 gets denied or didn't get picked in the lottery, is go through a cap exempt organization, such as I was saying, a nonprofit research organization, which is basically a nonprofit which does research, a
Mhm,
government research organization, which is, clear from, from the title itself what it is. Educational institution is generally universities, higher secondary, so not schools, but college level. If you're working for one of the colleges, you can definitely apply for a H-1B cap exempt. Or as I
mhm,
said, if you were your end client, that is, if you're working for a consulting company, whether you're doing management consulting, marketing, IT consulting, and the end client that you're going to be working for is one of these organizations, and you have an end client letter, then
mhm.
also you can apply for a cap exempt H1.
Okay.
So the other is it could be a non-profit related or affiliated to um, a university or higher education organization. So that is basically a teaching hospital. So Cornell or any hospital that you name, NYU, they're all related to the college NYU or the medical college Cornell, right? And they have residents, etc. So if it is something like that where they're affiliated to, and there is a contract that shows the affiliation, and It shows that the organization does on a regular basis, their everyday work is related to that affiliation, between the university and them, then they qualify for a cap exempt as well. So these are the few organizations that qualify. For cap exempt organizations, you don't have to wait for the cap. You can file your H1 at any point of time. You don't have to put a start date of October 1st. You can work with an immediate start date.
That's nice, Prashanthi. Thank you so much for taking that up for us. And let's move on to the next question that I got for you. And that is, what are the risks, of staying in day one CPT programs until we get our H-1B?
Yeah, so one of the ways that I said we could um, continue to work in the US if you don't get picked in
Mhm.
the lottery or if your H-1B cap is denied was that taking CPT, OPT or CPT. CPT is curricular practical training, which you're allowed to take with the permission of the school by showing that it is, there are two reasons for CPT, either hardship reason, financially you need to do it, or you have to show that it is related to your curriculum. And day one CPT is basically taking CPT on the first day of joining your program. USCIS has often questioned it, why you need to do, you need to, your school needs you to do a CPT on the day that you join. How is it that before you've actually learned, uh, the academic part of it, that you actually have to have work experience in those subjects that you've learned? It doesn't seem to make sense, right? So USCIS will often question the day one CPT. So we do get RFEs, requests for further evidence, and this usually happens when eventually when you file for a H1, we do get RFEs for the maintenance of status when you change from F1 to H1 to show that you maintain your F1 status. And usually they will ask questions such as, show us why the school required you to do a day one CPT. Show us what is the relationship between the work that you're doing and the courses that you're taking. So usually if the school has an executive program where, the work and study goes hand in hand and starts from day one because that's the nature of the program, and if the school is able to explain that and convince USCIS of it, then usually these H1s are approved. With reference to how long we're just talking about the risks, but with reference to how long can you be on a day one CPT, that depends on however long your school requires you to be on it, and the duration
Mhm.
of your study at that school. Sometimes USCIS has said that if you're on a CPT, then you may not qualify for OPT. That you've used up your OPT time. They've said that on and off in some instances, but they don't seem to be saying that in every instance. But that's definitely something to keep in mind.
Okay. Thank you so much for that, Prashanthi. And I think we should quickly take up a few more from the audience, and let's go with Samiksha on YouTube, asking what are the common reasons for H-1B denial and how can applicants address these issues in future visa applications? And there's a follow-up asking, can individuals whose H-1B visas are denied apply for other types of work visas such as L1 visa or O1 visa?
So, answering the second question first, yes, denial of a H1 doesn't mean that you can't apply for any other visa. You can apply for any other visa. And you can apply for a change of status if you're presently in status. Otherwise, you'll
Mhm.
have to apply for consular processing. Um, and, because you're not in status, so you won't be able to file for a change of status.
Mhm.
Going back to the first question, what are the common reasons for a H-1B denial? It could be many reasons, but now it depends really on the given political climate at that particular time. Some
Mhm.
reasons will always be there, but some new reasons always crop up, depending on what USCIS is, how they're interpreting the law at that time. And as I said,
Mhm.
the political climate is responsible for that, really. But
Right.
so they decide to interpret it more strictly or less strictly, depending on whether they're opening the gates or
Mhm.
they're closing them. Um, but there's some evergreen ones which will always, there will always be a denial. For example, if you don't meet the basic requirements of a H1, which is the job should be a specialty occupation. Specialty
Mhm.
occupation means a job that requires a bachelor's degree in a specific field. So if you file a H1, for example, for a janitor, it's not going to be approved because a janitor doesn't require a bachelor's degree. If you file a H1 for a doctor, it will be approved if they're licensed, because
Mhm.
it's very clear that a doctor requires at least a bachelor's degree, an MD, and a license. So there'll be no question on that from USCIS. Um, but in the scenario of consulting companies, there are some other nuanced reasons for denial of the H1, and that's basically availability of work. So if the consulting company is filing a H1 speculatively, meaning they're saying that, okay, we'll get them on the payroll first and then we will, hire them once we get a job for them,
Mhm.
meaning that we will put them on the payroll, but we will look for a job after we put them on the payroll. That's speculative. You have to show that you have a job as of the date of filing. And so, in this scenario, in this industry, in the consulting scenario, there are
Mhm.
often denials for the availability of work or non availability of work because they were not able
Right.
to show that work was available at the time of filing the petition. Though these availability of work denials have become less and less with the 2020 decision ITSERV versus Cessna, where
Mhm.
the judge said that you cannot ask for contracts and work orders and
Mm.
a lot of documentation to show availability of work. So there haven't been that many denials on that front, but mostly you also see some denials on change of status or maintenance of status. Like I was talking about the F1 to H1. If you're not able to show that a person is in status, then you could see a denial on that front. So these are a few common reasons for denial. There are many more, but these are a few common reasons that we can highlight at least this session.
Yes.
Time,
Thank you.
given the time, yeah.
Right, right. And we will keep discussing more, but thank you so much, Prashanthi, for taking that up first off for Samiksha. And I hope that was pretty much a good answer for you, Samiksha. If you have more questions or if you want more clarity on anything, you can keep dropping your questions in the comments. And well, oh, there's a follow-up. So let's just quickly take that up then. Can individuals whose H-1B visas are denied apply for other types of work visas? Yeah,
We
I
already
already
answered this.
did
Yeah.
this actually. Yeah. So cool. Thank you so much for that. And well, folks out there, we will definitely dive deeper into this topic on what do you do if your H-1B is denied. And we are definitely discovering many alternatives, that you can look up for. And yes, if you have questions directly to Prashanthi, or if you even want to contact her directly, the details are on the screen. You can call her on the number 212-354-1010, or even email her at prashanthi@reddyesq.com, or just visit her website, reddyesq.com. And don't go anywhere. We will just go for a short break and be back very, very soon. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444, or mail us at nipa@higheritpeople.com, or visit our website
www.highrightypeople.com.
Welcome back, everyone, to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and yes, we are definitely going to continue our conversation with immigration attorney Prashanthi Reddy. And today we are exploring the different alternatives, the different visas that you can take up in case your H-1B is denied. And before the break, we even took up many questions from your end. I hope you have uh, more questions and you can keep participating on this webinar with us, by commenting your questions. And don't forget to tell us where you're joining us from, okay? It's, not only to give you precise answers, but we'd love to know who is joining us from where. Right, Prashanthi? How you? I hope you're enjoying your
Absolutely.
time. And
I
yeah,
am, yes. We're getting a lot of interesting questions. So,
let's go ahead then. Yes, without further ado, let's take up this one from Smith on YouTube, asking, are there any specific strategies or tips for individuals to increase their chances of approval when applying for alternative work visas after an H-1B denial?
are there any specific strategies for individuals to increase their chances of well, it depends on really why their work visa was denied. Um, so it could be that there's no relationship between the denial of their work visa and you applying for a different kind of visa. So because the requirements are different in the H and they're different with the other work visas. Except for the E3, maybe the requirements are the same because you have to prove specialty occupation. So I would be careful with that. If your H1 was denied for specialty occupation, then I would be careful refiling it and make sure you have the job this time that requires a bachelor's degree in a specific field. But otherwise, if your H1 was denied for, say, change of status, the H1 was approved, but the change of status part of it was denied or extension of status was denied, that means you have a maintenance of status problem, which means USCIS is saying that you have not maintained your status. So even filing for another H1 then could be an issue, or filing for another work visa could be an issue because then they may not approve that change of status portion of it. So these are some things that to keep in mind, but otherwise the requirements for each of these are different. So you have to keep in mind the requirements when you're filing for each petition, whatever it might be.
All right. So thank you for taking that up. And Smith, if you have more questions, we are still here for a while. So let's move on to the next one from Shelly on YouTube, asking, how long does it typically take to obtain alternative visa compared to the H-1B visa?
What is the alternative visa? Alternative visas, okay, compared to the H-1B visa. Um,
Mhm.
it takes the same amount of time. Processing time for most of these are pretty much the same as the H1. So it takes the same amount of time. It really depends on whether you're outside the country and you need to apply for to the consulate, then that could be an added uh,
Mhm.
time that it'll take. But generally, it takes the same amount of time.
Okay. Okay. Anyway, let's move on to a question I have for you before we move on to more questions from the viewers. And that is,
Sure.
Prashanthi, what should we do if we suspect our H-1B sponsorship is from a shady company?
Hmm. Right. So, what should you do? You should file your H1. Isn't that the most reasonable course of action to take? You shouldn't file because if you know that the company is doing something that is fraudulent, then you will also get caught up in that any investigation that's taking place by USCIS. You might also get caught up in it, at least in the sense that your status will be at risk, even if you're not indicted for anything directly, criminally or otherwise. Um, for fraud, your status will be at risk, so you don't want to go with any company that is going through these issues, or
So
is
true,
likely
so
to
true.
go and is not following the right practices and is likely then to have some kind of fraud investigation against them in the
Hmm.
future.
Okay. All right. Let's move on to the next question I have. And in case, if our H-1B gets picked up but then denied, what are our options? We've already discussed quite a bit. But then the second part of it is saying like, can can our employer apply for a green card instead, or can we apply directly?
Yes, the employer, as I was saying, that is one of the ways you could overcome that H-1B issue denial is filing for a green card directly.
Hmm.
But if you're an Indian national, all the categories EB1, EB2, EB3, employment based categories, you can file, but you won't get the green card immediately. So there'll be some wait before you can actually work in the US. If you're already in the US on a different status, you can definitely file for the green card, and you might have to wait, even if it's EB1, for a year or two before you're able to get an EAD. So if you're willing to do that, absolutely. But there are also family-based green cards that you can file, in which case you don't need an employer. It's based on your relationship with a family member who is a
Hmm.
U.S. citizen or a permanent resident, and that if the person is a U.S. I'm sorry, a U.S. citizen, and you are an immediate relative meaning a spouse or a child or a parent,
Hmm.
then you should be able to get file for the green card and get it in 1 year, and in the interim get EAD as well in the next few months. So that's definitely an option, and better than being on a H1. So whether you're on a H1 or not, that's definitely the first option that you should use. A
Okay.
family-based green card if you're an immediate relative of a U.S. citizen or even
Hmm.
a permanent resident. It's not current for a permanent resident, but it does sometime become current. It was current last year,
Yeah.
and it retrogressed, I guess, last August and has never been current since then. But on and off, it becomes current for Indian nationals as well. So definitely look into those family-based green card categories.
Hmm. Good option. Thank you for that as well. Those suggestions. Definitely, Prashanthi. Let's go to another question. And if if you can tell us, can we do CPT for our first masters and then do it again with a day one CPT college if we didn't get H-1B after OPT?
Too many acronyms: CPT, OPT. So can we
CPT.
do CPT for our first masters and then do it again with a day one CPT college? Okay, so yes, you should be able to, but I would advise to be cautious because day one CPT, you're already doing that
Hmm.
first time. But I guess, continuing to be on day one CPT in every college that you go to, when you file the change of status from a H1, from an
Hmm.
F1 to a H1, which you'll ultimately have to do, you'll get an RFE and you'll have to overcome that to show that there was a connection between your CPT. There was a need. It was essential. It was an essential, an integral part of your, college
Correct.
for you to be on CPT.
Hmm.
If you're able to do that, then it'll get approved. Otherwise, it'll get denied. So I would be cautious about that.
Okay. Thank you. Thank you. And let's take up more viewers' questions now. I think we should take up this one from Monica, asking, are there specific industries or occupations that are more likely to receive H-1B visa denials? And what
I
alternative visa? Yeah,
didn't we? Didn't we? We took this up already,
no. But
or
okay,
maybe
I
it's
mean, yes,
exactly the
the
same.
question is, and
Is
what
exactly
alternative
the
visa
same.
option profession? Yeah, I think we have already taken up most of this professionals in these fields. Okay. Yeah, you
Let's
can
go to the next one
definitely,
because there's no point in
yeah.
talking about the same. Let's go to a new thing
Same
so
thing,
then
yes.
the
For sure.
audience
Monica,
knows.
I mean, you can just go through this webinar. We've already discussed this, so just rewind maybe if you can. And let's go to Vihan asking, I am on STEM OPT. My payroll has not run, okay, for initial 3 months for of my STEM OPT due to out of project. But right now I am in a project and I got my pay stubs on track from 3 months. Will this have any effect on my visa status? The follow up?
So you're allowed certain period of unemployment on your OPT. So if you are within that period of unemployment, you're fine. You're following the regulations. If you violated it, then you have a problem. I think it's 90 days. I don't remember offhand. I think it's 90 days
Mhm.
you're allowed to be, um, off a project. So please
Mhm.
keep that in mind.
Okay. Let's take up this next one from Rohan, asking, are there any specific strategies or tips for individuals who to increase their chances of approval when applying for alternative work visas after H-1B denial? I think we took this up as well, right,
Yeah, I think we're
Prashanthi?
taking the same questions. Yeah.
Yeah. Anyway, Prashanthi, I have my questions. Let's take that first. And if you can tell us, if our H-1B isn't approved, can we still do an MBA after our MS? And if we don't get H-1B after OPT, can we do another master's and get more OPT?
uh, yes, you can do an MBA after your MS.
Mhm.
And if you don't get picked in the lottery, then you will not get OPT again because the MBA is the same. It's a master's. It's the same level as your MS. You have to
Yes.
do it at a different level in order to get OPT again. If you've already received OPT in your MS, you won't get it again. So if you do a PhD, then you will get OPT again, but not another master's.
Okay. So not for double masters, but for a higher studies.
Correct.
Great. All right. So moving on, what hurdles might we face if the petition after our H-1B gets picked in the lottery?
Right. So you just have to ensure that you're filing your H-1B petition correctly. The hurdles are to file it correctly, basically. If you're filing it correctly, then um, you know
No way
uh,
that we'll get denied.
I mean, there could be still USCIS is unreasonable no matter what you do. Sometimes they will deny it, but at least
Mhm.
from our end, we can make sure that it's watertight so that we don't get an RFE. That use a good attorney to do that, or a person who knows what they're doing if it's an
Mhm.
employer. What hurdles? I mean, the hurdles could be that you get picked in the lottery, but your employer doesn't want to file the H-1B petition because, as someone was saying, the
Mm.
market is bad. So they may not have a job for you. So you might actually get picked in the lottery, but employer refuses to file the H-1. In which case, then that registration is wasted. You'll have to, unfortunately, get picked in the lottery again next year. And you may not be that lucky. So, what I tell people is even if it's a H1 that you're filing for the future,
Mhm.
meaning that you don't have to start the H1 immediately if you're the employer or the employee. You can file the H1, say that you require someone. You can, and then if you're outside the country, maybe you go for a visa when the job is available. At least that way
Mhm.
you keep your, you don't let that lottery pick go wasted. So that's one way of doing it, though it's complicated, right? Because you don't want to say something to the USCIS that is not true. So it has to be done carefully.
Right. Every step is important. So, friends, I think you have to put your head in the game when you get into this, especially your petition filing and your H-1B filing. Let's move ahead to one question. I think we got Gul asking, are there any restrictions or limitations on employment or residency rights with alternative visa options?
Not really. I mean, it's the same as the H1. If it's an L1, you can file for a green card. In fact, it's better than the H1.
Mhm.
Um, for the Australian visa, the E2, the E3, sorry, and the um, other visa options, the TN, there is an intent to immigrate issue.
Mhm.
Um, which the H-1B doesn't have. There's no intent to immigrate on the H-1, which means you can be on a H-1 and you can file a green card. You can have the intent to immigrate while being on a H-1. It's not so for the TN and the E. Um, L1, again, you can have the intent to immigrate, so you can file the green
Mhm.
card. So with the TN and the E, it's limited. So they say there is an intention to immigrate issue, which means that at the consulate you have to show whenever you're entering that you have no intention to immigrate. But that doesn't stop you from filing a green card while you're in the US. So yeah, it's slightly different. If you have a green card petition pending and you're going to the consulate and applying for an
Mhm.
E or a TN, that could they could question that your intention to immigrate,
Right.
whether you meet that requirement under that visa category or not. But it
Mhm.
is possible to do. It depends really on the officer. So there are some differences with each visa type.
Okay. Okay, thank you, thank you. And let's take up this next one on YouTube from Vinaya, asking how do visa quota limitations and priority dates affect the availability and processing times of alternative work visas for individuals denied H-1B visas?
So if you're talking about green card number limitations and priority dates, that doesn't really affect your non-immigrant petitions. There is no cap that like there is for a H1 for the E or for H1B1 for Chile or Singapore. There is a cap, but it never gets filled. So you don't have those cap issues, and you can file anytime for a H1B cap exempt or a TN or or E visa, Australian E visa.
Mhm.
So usually there's no issues with cap for those cases. So with reference to the green card numbers, it would be the same as the H1. You're waiting for your green card number to become available, and in the meantime, you are on, that non-immigrant visa. And I understand what you're saying, that if you have to keep getting extensions, does that somehow, will there be an intent problem if you have a green card pending? If you have an I-140 pending? Um, I don't think they will look at it that way. Um, because you don't have an intention of immediately immigrating.
Mhm.
So it's not necessary that if you go for a visa that they will deny it if you have an I-140. You have to basically show on a case-by-case basis that there's no intention to immediately immigrate because, the priority
Mhm.
dates are not current anyway. So
Right.
you'll still be able to file, I think, a green card on these categories without jeopardizing your intent required under these categories.
Right. Okay, thank you. Let's take up this next one from Hassan on YouTube. Hi, Hassan, how are you doing? Thank you for joining us and your question as well. So, Hassan is asking January 24, my petition got approved, but I couldn't apply for visa. How many days can I wait?
There is no limit within which that you are supposed to apply for a visa after your H1 gets approved. You can really apply anytime during the duration of the approval. So
Okay.
whatever the term of the approval is during that time, you can apply for a visa. If it's taking longer, like a year or 2 years, then you have to have an updated offer letter from your employer saying that the job is still available and maybe an explanation as to why you did apply for a visa for so long. But otherwise, there's no
Okay.
time limit. It can be during
Mhm.
the petition pending period, anytime.
Okay. Thank you so much for taking that up for Hassan. Let's move on to the next question. This is on YouTube again from Rohan. What are the potential long term consequences of this denial on my career, finances, and personal life? And what specific steps can I take to mitigate these risks and ensure a successful outcome in my immigration journey?
I wish your question was more specific. It's very broadly based, but in general, as I said, having a H-1B denial doesn't necessarily mean that. It will affect your further immigration journey as long as
Hmm.
you follow the rules. As long if you have a H-1B denial and you have no other status and you have not applied for any other status before the
Hmm.
denial, then you have to leave the country. As long as you
Hmm.
don't remain in the country and stay and accrue out of status period. If you're out of status for a period of 6 months or more, then you accrue unlawful presence and you will be barred from entering into the country for 1 to 10 years, depending on how long you've been out of status for. So be very careful. Even if you get a denial, make sure you otherwise maintain your status. Then that should have no consequence on your further immigration journey as long as the H1 was not denied due to some fraud committed by you.
True.
If you were not responsible for the denial in any way, it was just a denial because you don't qualify and there was no fraud involved, or the fraud was committed by the employer, and you had no part to play in it, then it doesn't affect your immigration journey.
Great. Well, thank you for taking that up for Rohan. And Hassan, who you just answered just now, says thank you. And well, he's doing good. Thank you so much, Hassan. And I think we should wrap up. We still have more questions. One more question, maybe last question for today. Um, but it's almost the same thing, so we've already taken this up as well, because Vijay also is asking, are there any visa options available for individuals whose H-1B visas are denied due to issues with the employer, such as company shutdown or layoffs? Maybe you can just give it
Right.
a quick
Yeah.
answer.
So no matter what the reason is for the denial, the options are still the same.
Okay.
You could, of course, of course, I mean, if in that case where, um, yeah, the 60 days grace period doesn't apply to you because you're not presently on a H1. So yeah,
Mhm.
you'd have to find alternative uh, options, like I mentioned, one of the visas. Or if you're not cap exempt, then you would file a H1 transfer to another company before it gets denied. Once it
Mhm.
gets denied, then you're out of status. So you want to make sure you do that, before the denial. If you think that there is a chance of denial, usually you will know when you get the RFE. Your attorney
Mhm.
will know what the chances are and how difficult it is. And if it is obvious, then I would say that file the transfer before the denial actually happens. That way you're not out of status. So that would definitely be a good strategy to use.
Absolutely. Thank you so much, Prashanthi. Thank you so much today, actually, for joining us and, being so patient and answering all these questions from us and the viewers. And thank you also, for, um, yes, I mean, I think we were able to take up almost all the questions. Yes, we could take up all the questions today. So I'm so
That's great.
grateful for that, too. So thank you so much for doing this today, Prashanthi.
You're welcome, Nipasa. It's always a pleasure to be here. As I always say, the questions are always interesting and insightful. So I'm always happy to be here on Wednesdays.
Thank you. And I'll see you again the next Wednesday. And until then, you take care and have a splendid week ahead.
Thank you. Bye bye.
Bye bye. And folks out there, you can always contact Prashanthi directly. Her number is displayed on the screen. You can note it down, 212-354-1010, and even email her on prashanthi@reddyesq.com and visit her website, reddyesq.com. Thank you so much, Prashanthi, once again. Bye bye.
Take care. Bye.
And folks out there, thank you so much for joining in today. I had a great time, and thank you for being so participative as well. Your questions were great, and I hope that you got your answers. If you still have more questions while you're watching this after the stream has ended, you can always keep asking, because we have our experts who will be very happy to answer to you. And you can definitely even contact me directly if you have any questions. We even have well, my number is displayed on the screen. You can note it down, 408-335-6444. You can email me at nipa@higheritpeople.com and even visit our website, www.higheritpeople.com. And have a great rest of the Wednesday. And folks, this is not a goodbye because I'm going to see you again very, very soon at 2 p.m. EDT. I'm going to join in with another webinar, and we are going to have none other than immigration attorney Uma Mantravadi joining us to share her insightful advices and everything she has to share with us. So don't forget to join in and take care, stay safe. Don't forget to subscribe to us, like and share also. Our handle is Immigration and Jobs Talk Show. And you can even follow us on um, LinkedIn, Twitter, on Facebook as well. And definitely don't forget to subscribe to us. This is Nipasa Pradhan signing off for now. Bye bye. Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.